Okay, let's see. My daughter's transitioning to school-based services, and so far, early in the process, there have been two violations of special education law that have been admitted in writing, although I don't think the school employee is meant to admit them. One of them was a violation of confidentiality. This, along with some other small hiccups, have made me incredibly nervous about this process. Would it be smart to go ahead and reach out to a lawyer or advocate about this, or should I wait until we have an official IEP in place? I don't want them to make it out like I waited and got a lawyer because I didn't get what I wanted. But I don't want to come off as hostile either. How is the best way to handle situations like this? Okay, I mean, I think this is a good question. Now, I'm assuming transition to school-based services would be the 3-year-olds or preschool services or initial IEP. That's how I'm going to treat the question, okay? So you're in that beginning process, and it sounds like you have a grasp of what the process should be like, which is good, but keep these things in mind, okay? Earlier in the process, there's going to be natural hiccups. It's just following the rules, and some people don't know the rules. And confidentiality, for example, is a minor, if not incredibly small level violation. It may not be to you, and it may not be, let's say you're an educator and they scare the hell out of you going, oh, you don't violate FERPA and people's confidentiality. But in reality, there's no real punishment for violating a student's privacy rights. And that's unfortunate, but it's true. FERPA is a paper tiger. It has, has, I guess, the best intent in mind, but at the same time, it's a government privacy program where there's no consequence for the government violating that confidentiality. That's why it's not like HIPAA. All right, HIPAA has to do with private medical people that could lose their license, and that's the thing. The government loves to sit there and provide opportunity to sue the hell out of private people, but they protect themselves in the form of immunity. So let's say public education people have very, very good codified immunity, and so it's very, very difficult to hold school personnel accountable on even a remotely small level compared to, let's say, doctors. All right, so the confidentiality argument, yeah, it's important for them to maintain confidentiality, but is it something that would trigger or denote the need to get an attorney involved? No, not unless you can point to actual harm done to your child. And then at that point, yes, I think a special education due process complaint or mediation would be in order if you could prove that the result of the violation of confidentiality resulted in educational harm to your child, regression, or stagnation. Those three factors. If not, then it's just considered what's called a procedural violation, and that's this. Don't do that again. So there you go. That's all that happens. All right. You move on to the next thing. So if there's other small hiccups along the way, those are to be expected. And if you're new in this process, then I'm telling you, you're going to have to expect it every year, every year, every year. And in some years, it's going to get worse and magnified to the point where, yes, an advocate or an attorney is necessary. Usually it happens at transition points, like where you're at currently, that transition point from preschool to kindergarten, from elementary to middle school, and middle school to high school. Those are the big transition points to where the schools do a really bad job of the handoffs. They do a really good job of maintaining good current evaluation data. There's so many factors involved. And so you typically have a reprieve of a couple years before you have some kind of major hiccup. But little hiccups, I just expect them, guys. They happen all the time. Once again, those hiccups would be considered procedural in nature, violations in procedure. And unless you can point that the violations resulted in educational harm to your child, equating to stagnation and equating to regression, which you need to sit there and be able to prove through the school documentation or your own data, okay? But that's how you prove those things. But if you can't prove those things, then they're hiccups, they're procedural violations, and that's not due process worthy. It is not something you get an attorney or even an advocate to correct. All right. You just, in your own mind as a parent, you sit there and say, hey, we need to do better. All right. I know you guys sort of, tripped, skin your knee. People make mistakes in this process. There's a lot of rules. So you got to have a certain amount of patience with it. At the same time, I think that you're very correct in having some concerns and having some trust issues. And you should always have trust issues. You're dealing with your child here. And I would never put a smidgen of trust in 100% or even 50% knowledge or compliance in this process. That's why you as a parent have a stake in the process. That's why you have a legal right to go out and get an attorney or an advocate to assist you in this area, whereas in other areas in the public school, you have no right to get those kinds of professionals involved to assist you. You do in this area because you have an active role. You have your own individual rights as a parent, as an advocate for your child. You also have a say and a voice in the development of your child's program to make sure that it is designed in such a way that it's reasonably calculated to provide your child a free, appropriate public education. And sometimes you're going to bring ideas to the table that they're not going to agree with, okay? And you have a choice at that point. You can either get an advocate or an attorney involved if you feel so strongly that this is the program that my child needs, and you can prove that by not having it, it's going to result in stagnation or educational harm or regression for your child. But sometimes you have to wait to see if that IEP that was developed is going to result in progress for your child. And I'm not even talking minimal progress. I'm talking it's got to be tangible, measurable progress, because that's what's attached to FAPE. And sometimes you have to wait. And I'm not saying you have to wait for an entire school year to sit there and show, hey, I was right in what I suggested. You guys were wrong for rejecting that. And I was right for what I suggested because, look, she's not making progress. And this is why she's not making progress. And at that point, yes, you can point to the harm, the regression, the stagnation. And at that point, that's when you would trigger getting an attorney like myself or an advocate involved to sit there and reset that IEP program, to have corrective action inserted into it. But if you're at the very beginning of the process, then yes, you sort of need to see it through, see how the IEP is developed. And then there's nothing wrong with you consulting with an advocate or an attorney to sit there and sort of eyeball it and tell you if they see the kind of problems that you do, and to confirm some of the concerns that you have. There's nothing wrong with that. But most of the time, if it's your first IEP, unless it's something drastic with regards to they did not conduct a thorough evaluation and they did not make a proper offering of FAPE available to you, meaning that if her diagnosis is, let's say, autism, and they half-ass it and say, well, we'll do drop-off services a couple times a week with a speech-language pathologist and throw some OT in there. Well, that's not what the science says we need for autism spectrum disorder. What the science says is that the child with ASD at that age requires a full-time integrated preschool setting with an array of different interventions, including ABA therapy, speech language, OT. It's all got to be in there. But it's got to be considered a full-time preschool program, it's got to be at least 25 hours a week. So you see, that's what it means to where they've got to make an offering of FAPE available to you. And it's got to be connected to their thorough evaluations of the child that would give them a good idea of whatever your child's needs are. All right, they've got to be connected together. They can't sit there and separate out there in outer space. So they do have a duty to thoroughly evaluate your child. That's more important than confidentiality, frankly. And what are they going to do with those evaluations? Were they thorough enough to lead the IEP team to the conclusion that your child needs this amount of services? And then they may need to make that available now or whenever that time period is, and not this thing to where, well, this is what we give all 3-year-olds, or this is all we can offer. Well, that's not true. The standard for providing your child with a FAPE is the same for a kindergartner, same for a preschooler, same for somebody that's 20 years old. They are entitled to the same level of FAPE. It's not different for preschool. It's not any different for secondary education or elementary, guys. It's just FAPE is FAPE, and they have a requirement to provide it. And lack of funding or lack of classes or lack of whatever is not an excuse under the law. So yes, you wait until that's developed, and it doesn't make you look bad. You should wait until things are developed, because that gives you the proper perspective on what to do next. All right? It's just all the stuff that you're seeing as far as red flags along the way. I'm glad you're paying attention. That's good for you. Most parents don't do that, especially at that early level, and I'm glad that you are. That means that you are already halfway there to being the kind of advocate you need to be. Okay? So congratulations. But wait until it's developed. Wait until they make an offering. And if they don't, then you have the recourse available to you to reset that program and get it to where it needs to be. And I wouldn't rest on that. Because once they institute a program, especially if it's down here, when in reality, her level of FAPE should be here, then what you end up doing is this becomes the level of FAPE. The next year, her level of FAPE is based upon that. And the next year based upon that, instead of keeping it up here. Okay? So you always want to try to pull it up to where it should be and needs to be. And if you're not necessarily sure 100% on what that level is, that's what an advocate's for. That's what a special education attorney is for, to be able to provide you that insight that you might not be 100% on. Okay? Good question.